My lords, I may be permitted to take. My lords, I may be permitted to take the original file, my lords, of our governors.
Who appears for the office of the governor? Sir,
Yes, my lord.
Solicitor General, sir.
Yes,
This
my lord.
original file of the governor, I'm returning to your advocate on record.
Please,
I'm grateful, your lord.
Yeah.
please,
Whoever is it? Madam Kotbet.
oblige.
Obliged, my lord.
Madam Adu. Yes. ಇದ್ದಾರೆ ಅಟಾರ್ನಿ ಜನರಲ್ ಎಲ್ಲಿದ್ದಾರೆ ಒಳಗೆ ಬರ್ತೀನಿ ಒಂದು ನಿಮಿಷ ಎಡಿಎಸ್ ಜಿ ಅವರೇ ದಟ್ ಅಟಾರ್ನಿ ಜನರಲ್ಸ್ ಮ್ಯಾಟರ್ ಕೆನ್ ಐ ಟೇಕ್ ಇಟ್ at 2:30 if is not a problem for him? All right, then all right, yes. Respondent ಯಾರಿದ್ದಾರೆ?
They appear for
Yes, yes.
respondent.
ಕರೆದು ಬಿಡಿ.
List number 2, field number 1. I'll start with the list then. Javadi sir, I'll start with the list. When it comes, you tell me. Yes. I'll be taking the first list. Yes. Everybody. First list ಕರಿತಾ ಇದ್ದೀನಿ ಕರ್ದ್ಬಿಡಿ ಅಲ್ಲಿ he's not yet come ಕರ್ದ್ಬಿಡಿ after he comes I'll take it. Yes, take it, call the first list. Sir ಅವ್ರು sir ಅವ್ರು ಬಂದ್ಬಿಡ್ಲಿ. List 1, fresh matters, field number 2.
In the meantime, next. Next.
Field number 3.
Same. State, sir. Yes. ನಿಮ್ದು ಅಷ್ಟೇ ರಮೇಶ್. ಅವೇ ಪ್ರೋಟೋಕಾಲ್ ಗೊತ್ತಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು. ನೋಡ್ಕೊಂಡಿರೋ. Page 29, sir. No way for interim order. Take chance after vacation. ಇಲ್ಲ ಕೊಡೋದ್ರೆ ನಾನೇ ಕೊಡ್ತೇನೆ. All the family members. Correct. Page 29 ನೋಡಿ. No false case.
ಫಿರ್ಯಾದಾರರ ಮೇಲೆ ದೊಣ್ಣೆ, ಕಲ್ಲು ಮತ್ತು ಕೈಗಳಿಂದ ಹೊಡೆದು will list it after vacation. List after vacation. Yes. Will not dismiss it. Continue ಆಗ್ಬಿಟ್ರೆ ನಾನು ನಿಮಗೆ ಕಷ್ಟ. Change ಆದ್ರೆ ತೊಂದರೆ. Yes.
Correspondent 2, madam.
Kavya, A2, A3, A4, Kashkan.
Respondent
Respondent. A learned counsel so and so undertakes to enter. ಯಾವುದು serial number?
5, madam.
First list.
Yes, madam.
Ajit.
Second list, sorry, madam.
A1, A2, A3, Kashkan. Sorry, ಅಲ್ಲ A2,
2, 4,
A3, A4, Kashkan. Next.
2 to 4, madam.
Arun Kumar. 2013 CC, I will not interfere now. Huh? No, no. 11 ವರ್ಷ ಆದ್ಮೇಲೆ I will not interfere in a 482. The subject petition, the petitioner is before this court now seeking the following prayer. The crime is of the year 2012 and the CC of the year 2013. 11 years have passed by. The petitioner is now knocking at the doors of this court, contending that the crime so registered and the charge sheet so filed after the registration of the crime are all an abuse of the process of the law. There is no ground made out for interference at this juncture, more so in the light of the fact that the matter is pending before the concerned court for the last 11 years. If the submission is that the trial has not yet commenced, the trial court shall endeavor to conclude the proceedings with an outer limit of 6 months, if not earlier. Next. Ordered accordingly.
The disabilities, children's benefits have been eaten away by these people.
What, impossible to stay.
Yes,
Yes.
7, 8 and 7.
List after, no representation, list after 4 weeks.
Your Lordship,
Registered-
serial number 7, Your
registered
Lordship.
Not to list the matter prior to the expiry of
Lordship.
4 weeks. Next.
Serial number 7, Your Lordship. I am appearing for petitioner.
I have not yet come to 12. Wait, sir.
8.
Same, 8. 4 weeks. Yes. Nishant, in the meantime, next.
ಅಲ್ಲ, ಇದರಲ್ಲಿ issue my lord, they're taking section 5 of the act. Section 5 of the act has no applicable.
ಯಾವ್ದು serial number 9 ಅಲ್ಲ?
Yes, my lord.
ಕೊಡಿ. Identical matter stay ಕೊಟ್ಟಿದ್ದೀವಿ ಕೊಡಿ.
ಅಲ್ಲ, ಅದು that exorbitant interest rate.
ಹಾಗಾದ್ರೆ Thursday ಆಗ್ತೇನೆ in the fresh matters list. Tag this petition along with criminal petition 4037 of 24.
Ma'am.
List them both.
Sorry, not this matter.
What?
Next matter.
ನಾನು ಓದಿರೋದ್ಮೇಲೆ ನಂಗೆ ಡೌಟ್ ಬಂದ್ಬಿಡುತ್ತೆ.
Sorry,
In the tag this petition in the meantime. Yes.
10.
this matter, my lord.
ಇದ್ರಲ್ಲಿ
Yes.
ಇದೇ ಹೇಳಿ ಕರೆಕ್ಟ್.
Yes.
ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 4 weeks. ನಿಶಾಂತ್ಗೆ ಗಾಬರಿ ಮಾಡ್ಬಿಟ್ರಿ. In the meantime. You will just stop at 12. We'll hear the Attorney General and then get back. Yes, sir. No, by the time you came, I finished 12 cases.
So one of the virtues of virtual hearing is that we can travel to many places trying to finish a case.
Yes, sir.
The pleadings are now complete.
ಅದು ಫೈಲ್ ಕೊಡಿ. ಇದೆನಾ?
Counter affidavit and our.
May kindly permit me to pass the memo notes where senior Acharya has been appointed as the state public
Oh,
prosecutor.
fine. Yes.
Memo with the
All right.
officers.
Senior. Sir, Professor, sir,
Corporation.
both of you.
Corporation.
Oh, sorry.
I am for the 6th response.
All right.
It's very interesting and to see my learned
Lord.
friend here.
The Lordship's kindly you.
Please go ahead.
Lord, I'm appearing for respondent number 1, Miller.
Oh, government.
Respondent number 1.
Other state.
State.
Yes, sir.
My Lord, I would like to raise a preliminary objection, my Lord, with regard to the maintainability of the writ petition.
All right.
Because after the filing of the writ petition, my Lord, there are 2 developments. One is the judgment of the Supreme Court in the state of West Bengal versus Union of India. And other, in my Lord, is the division bench ruling of this honorable court following that judgment, my Lord, which in effect has dealt with the power of the CBI, interpretation of the provisions of the Delhi Police Establishment Act, etc.
I mean, matter that was sent to the Supreme Court.
Yes.
Please, no, yes. So that question is there, my lord. This is virtually a dispute between the state and the union
Not at
with
all.
regard to the right to
Not at all.
investigate. Please,
I don't agree with that.
please, ma'am.
It is not a dispute between the state and the union. It is a dispute with regard to an individual or the corporation that is said to have siphoned off the funds or whatever it is, misappropriation of funds. And the Union Bank of India is here wanting it to be referred to the CBI. That is all. Where is the state and the center dispute in this?
No, my lord, here the question is, the writ petition relies upon the circulars issued by the central government, which in effect, my lord, that is the foundation of the prayer in the writ petition. And the question is whether such circulars can interfere with the power of the state government, my lord, and the state police.
I will answer that
To-
on merits.
Please, madam.
I will answer that on merits.
Please.
But I will not hold that it is a dispute between the state and the center.
No, my lord, kindly similar, of course, subject to the identical question was argued in the, before the Supreme Court. The state union took up the preliminary objection, my lord. It is only a dispute between the
West Bengal-
CBI
in the
and the
West
West
Bengal
Bengal state.
In the West Bengal case.
Yes. Dispute is, that was the specific,
No, if apex court has held so, then we will be bound by it. Let's see.
no, that is why, my lord.
But
Only-
division bench definitely bound by, but if there is something, if it is between the center and the state.
Yes.
if that
No, my
is the
lord.
issue-
Before in the West Bengal case, my lord, the question was with reference to the power of the CBI to further investigate into cases in West Bengal where the state government has withdrawn consent.
Consent, whichever.
And the specific objection of the Union of India in the case was that suit was filed by the state, my lord, state of West Bengal. Union of India contended, raised a preliminary objection. The suit was filed under Article 131. The contention of the union was that 31 is applicable only if the dispute is between union and the state, not between the state and the CBI. Now that was answered by the Supreme Court, my lord. It rejected the contention of the union that CBI is a different entity. But the Supreme Court went into the details and held that it is under the supervision of the central government, and in effect, it is a dispute between union and the state.
Supreme Court has answered that it is a dispute between union and the state and only the apex court has to decide it. Is that the finding of the apex?
Yes,
court?
yes, and it overruled the objection of the union and said the suit is ordered to be, may I just pass on that to you.
Attorney General, sir, since he's on maintainability, I'll just look into that judgment and get back. Yes. Paragraph, sir.
I thought we were having, Para 2, my lord, on filing of the suit, preliminary objections have been raised by the defendant Union of India with regard to the maintainability of the present suit. Though the judgment, through this judgment, we have dealt with the contention of the parties on the aspect of maintainability. Because, my lord, Article 131 says the jurisdiction of all other courts are barred, where the dispute
Yes.
between the union and the
And the state, correct.
Right. Now, para 4 onwards, my lord, the objection of the union saying that it's only a dispute between the CBI and the state of West Bengal, not. Well, the plaintiff submitted that CBI is directly under the control of the union, and therefore it virtually amounts to a dispute between the union and the state.
Yes, sir. This may require an answer. Yes, sir. Same, sir. Right. No, I was not aware of this. We'll decide about the maintainability first.
Also, I raised the question of locus.
Of the Union Bank of India.
Bank. To file a petition, using a investigator.
Yes.
So they
What
have to
responded?
decide.
Yes, sir. We'll cross the threshold bar
Of course,
of maintainable.
need to do that.
Yes.
I have no difficulty in addressing that question. The writ petition is premised on a principle which does not lie within the domain of the Delhi Special Police Establishment Act at all.
Yes.
Because both the State of West Bengal judgment and the judgment enters a field where the DSP Act governs and what should be the regime. This is the fallout of the Delhi West Bengal judgment, the constitution-based judgment. It doesn't lay down any new principle as regards. Since the question of maintainability of a suit was raised, the court has to answer that. Again, within the framework of the DSP Act. The controversies were within the framework of the DSP Act. Once, if the court is able to see and is persuaded, if I am rightly persuading, that we are not in the domain of a DSP Act at all, then the question of maintainability, taking recourse the judgments, I think will be misconceived. Now, why do I say it does not fall within the scope of the DSP Act? The DSP Act is of 1940. The Banking Regulation Act came in 1949. Much later, Section 35A come much little later. Before I go into the relevance of Section 35A and why the Reserve Bank of India as the custodian of the integrity of banking transactions under the Banking Regulation Act and also on the RBI Act, before I get into that. If there is a special legislation to deal with the functions, activities, supervisory regulations, etc. of a banking entity, then in due course of time when RBI finds and that the bank frauds now require a special attention, then Section 35A comes in. Under the authority of Section 35A, Reserve Bank of India issues a master circular. That authority of the Reserve Bank of India to act under Section 35A is neither regulated, conditioned, or qualified by the DSP Act at all. The DSP Act contemplates when offences within the territorial jurisdiction of a state are committed, where by reason of the federal dispositions, the state investigation authority will have the primary duty responsibility to investigate and prosecute. The central government can still come in. So a special allowance is given by Parliament to the central government to come in and say, look here, I would like to investigate with an agency which is specially created under this special law. So would that be a matter of propriety for the central government to issue a notification under Section 5, having regard to determination under Section 3 of the DSP Act, that I would do it unilaterally? Therefore, the Delhi Special Police Establishment says you would not do it unilaterally. We have a federal structure for good reasons. The state government will come and say, yes, I give my consent. So it is a matter of high level of understanding between the central and the state government, where the state government will ordinarily yield to a central government's understanding of the need, importance, and relevance of the CBI undertaking an investigation for a variety of factors. Will ordinarily yield, because there is no conflict or hostility between central and state government in this regard. It is understanding of both the governments works at a certain level of responsibility and transfer of, therefore they will ordinarily yield. But there are circumstances when the state may say, what is great about CBI to come into this matter? And therefore, we have our public order, law and order, administration of justice. If they are state subject, we are competent to enter into the investigation and prosecute them. That's how the DSP Act will have to work, and it has worked for a long time. Consents are being given. But when, for other reasons which are not entirely legal, if state and central governments begin to have differences of views on giving consent, so we enter into a very new stage of federal disagreements. Whether they are good or bad is a different question. We are not arguing that question today before the court. So since central government will notify that, can you kindly turn to the DSP Act for a minute?
Delhi Special Police Establishment.
Delhi Special Police Establishment Act.
Banu Prakash is good. Yes.
Because the Act contemplates setting up a special police force. Now kindly turn to Section 3. The central government may, by notification in the official gazette, specify the offences or class of offences which are to be investigated by the Delhi Special Police Establishment. Then comes Section 5. The central government may by order extend to any area. Once it has notified that, under Section 3, that central government may by order extend to any area, including railway areas, in a state not being union territory, the powers and jurisdictions of members of the Delhi Special Police Establishment for the investigation of any offences or class of offences specified in notification under Section 3. When so-and-so is notified, said police establishment extend to any such area, a member thereof may, subject to any orders which the central government may make it on his behalf, discharge the functions of police officer in that area, and shall, while so discharging such functions, be deemed to be a member of the police force of that area and all that. Now, kindly turn to then Section 6.
Consent.
Yes. Nothing contained in Section 5 shall be deemed to enable any member of the Delhi Special so-and-so to exercise the powers and jurisdictions in any area, not being its, etc., without the consent of the government of that state. So if you keep aside this act for a minute and look into the Banking Regulation Act and Section 35A,
A.
yes,
Yes.
this act, of course, has gone through large number of revisions, amendments, and so on and so forth. But if the original statement of objects and reasons, which are contained in 2 or 3 paragraphs. Lordship will permit me to quickly read them. Because unlike what happened in the
Power
early
to issue directions.
that's true. I'll just come to that.
Way banking.
I'll just come.
Yes.
I'll just come. If the why is 35A conceived at all?
Yes.
If 35A is conceived that in the public interest or in the interest of banking policy, or to prevent the affairs of any banking company being conducted in a manner detrimental to the interest of the depositors or in a manner prejudicial to the interest of the banking company, or to secure so and so, etc., necessary to issue direction to banking companies generally, banking companies in particular, to issue such direction to banking companies or the banking company shall be bound to comply with directions. Now, these are very words of wide import. Now, today, a banking institution, unlike the early parts of the history of banking institution, occupies the core of the economic and fiscal discipline of a country. So anything which impedes such fiscal discipline or may have an impact on the fiscal discipline, the discipline of banking industry, has a large, wide range of implications for the entire finance and economic transactions. A dent here, a hole here, something happens somewhere with the banking industry means it may have large implications. Therefore, 35A comes in, and the RBI says, I will issue all kinds of directions possible to ensure the integrity of the banking functions and the integrity of a bank as a public entity. Where a bank is not merely now a person who receives a deposit and then gives some interest and gives it back. So it discharges a wide range of functions. So it discharges function relation to development of the economy, etc. If that is the position, if Reserve Bank of India issues a master circular in exercise of its power, and it sees that in order to ensure that the integrity of banking function will lie within my domain under 35A, it doesn't have to go to any other authority, including a central government, to seek assistance, solicit opinions, views as to how I will instruct banks to act in terms of my directives. So when these directives are issued, what do they intend to achieve? I'll take your lordship to the directions in a while. So if looking at it objectively, if there are 2 ways of looking at this 35A, one is to read it as expansively as possible to ensure that in the interest of all these matters which I just now talked about, the economic and fiscal discipline and the role banks play today in entire economic activities of the nation, if they have to be read expansively. And RBI says, I would probably conceive that a specialized agency would be the best suited agency to look into any offenses, either in relation to the banks or committed through the instrumentality of the banks, either by officers of the banks, with or without connivance, or an entire set of outsiders who use the bank as a tool or instrumentality for committing certain set of offenses.
One clarification.
Yes, Your Lord.
Which is the bank in the respondents involved in the case? For RBI to direct, the particular banking institution should function with integrity or it has crossed the limits and other things. Which is the bank involved here in the state of Karnataka?
Union Bank.
Union, that's the petitioner.
That's right.
Huh.
Let me
If the Union Bank itself is...
let me try to
Yes,
develop an argument.
Yes.
That's why when I looked at 35A, I could look at it very narrowly. It is a set of indoor directions for the banks. You can read it like that. But I don't think that should be read such restrictively and narrowly. They are not meant to occupy a mere indoor direction to the banks at all. So if therefore Reserve Bank of India conceived a larger role to be played by it in ensuring that the integrity of the banking system, and in particular any particular bank, have to be so directed, supervised and monitored and regulated, and it issues a direction, I suppose just as 35A will have to be read expansively, the directions issued by the bank also will have to be read relevantly and expansively. So I'm not looking at an offense committed by an officer of the bank along with somebody outside the bank. Because there can be a wide range of ways today in which bank as a banking entity can either become a victim, can either become a tool, or can become a player in the field where offenses could have been committed. I am not concerned with what class of offenses are being committed. I think for the purpose of 35A and the Master Circular, the focus is not on what kind of offenses. The focus is on ensuring that whatever be the offenses committed, the integrity of banking industry, integrity of banking transaction must be ensured and guaranteed. So today a wide range of offenses where banks come into play. PMLA Act also, is involved in many circumstances. Therefore, the kind of transactions which a person through monetary transaction, we have cryptocurrency today. So we have all kinds of things which happen, which through technology can defy very conservative notions of banking functions, etc. Therefore, if we take a larger view of what the Reserve Bank of India thought should be done, it then designates in exercise of its authority under Section 35A, saying that CBI would be the investigating agency for looking into offenses which relate to banking transactions. I'll go through the Master Circular in a while. In order to therefore either to issue a Master Circular under Section 35A or issue guideline directions of any nature whatsoever, because the RBI has given a wide authority under this. You can give it any designation or name. It hardly matters. The power is available, then what it does will only matter. Therefore, the Master Circular says that CBI will be designated as the only authority to investigate certain class of offenses. For doing that, does the RBI require to go to central government? The RBI does not require to go to central government at all. And what the RBI does under this provision, including a Master Circular, will not again fall into the domain of a central government to act under Section 3 and 5 of the Delhi Special Police Establishment Act. They operate in distinct parallel fields. So a certain class of offenses, a certain set of entities and establishments in respect of which the framework of law is entirely different and therefore falls within the special legislation. Delhi Special Police Establishment is kept out. If 35A or is there any provision enacted under the Banking Regulation Act, including the Master Circular that would have been issued by the Reserve Bank of India, which said, I require the consent of central government, and central government alone will determine whether CBI can go and investigate at all, then the RBI could have done that. But RBI, in all its wisdom, having a regard to the width of the power available under 35A, I said, no, I don't require that recourse at all. I don't require the assistance of central government to ask CBI to investigate. No, kindly look into the Master Circular. Therefore, the two legislations operate in parallel fields. Delhi Special Police Establishment does not condition, qualify, or limit the Banking Regulation Act in any manner whatsoever. We are not concerned with certain offenses where, like any IPC offenses, which may not have a concern with a particular entity or an establishment, which have implications for the economic and fiscal discipline of a country. We're not really talking about mere forgery or conspiracy or collusions, etc. They will be offenses. But they are offenses committed using bank as a tool or an instrument. Now, I ask myself a question. If the corporation which has laid a complaint against the managing director and the executive director of the bank early in point of time, the chairman of the corporation lodges an FIR. And he says the managing director and the ED are involved in these offenses. A very ingeniously manufactured FIR. And then now it knows that the charge sheet shows that the author of the FIR himself is an accused. So I look at it like, why did it travel like that? They could have straight away said, neither the MD nor the ED, but some officer of the bank is involved. We also find some outsiders who had used the bank as an instrument or a tool for committing offenses. The corporation could have come clean with an FIR which is of a highly respectable nature. The corporation did not do so. Which means I gather, or any independent observer would gather, that the lodging of the FIR by the head of the institution, the corporation, was with malafide intentions. I'll try to expand that. But I'm not going to put my stand heavily on that. And therefore, every strand of the certain events in this happen will have certain connections. So as far as I am concerned, if I am right in saying 35A and the Master Circular are under a statutory framework which are not conditioned or qualified or limited by the Delhi Special Police Establishment Act in any manner of consumption. So let's request a lot to look at the Master Circular at this point of time. Page 153. 64. Huh? Which is 53. 156 it starts.
No, now the bank has registered a complaint, that is at Annexure A.
That's right.
Now you are asking this complaint to be investigated by the CBI.
Because under the Master Circular,
Hmm.
the CBI is the only investigating agency.
No,
It is not that there
this
is
is
small,
this
there's a
is
small mix
concerning
up in the
this
play.
is
I'm sorry.
concerning a corporation.
Yeah.
There is no other bank, is any bank involved in this, except Union Bank of India is involved in this?
We don't know. We don't know. Not-
Because it is a state-owned corporation, and Union Bank of India is complaining, has registered a complaint against a state-owned corporation.
Some monies are gone to Hyderabad and some other places.
All
So
right,
what
it
banking
has-
transaction, which banks are involved, how that is a matter for a later day consideration. But
It's-
the Annexure H, Annexure A,
Yes. Annexure?
one. Let me first read yes, the Annexure A is a complaint by the bank.
Yes.
So he talks about all that events in relation to the
Right.
affair and how the bank has been subjected, so and so.
Yes.
And at page, immediately after subparagraph 5, it says, "Hence, to ensure a free and fair investigation, we request you to transfer so and so to CBI."
Yes.
Now, there is no estoppel in making such a
Subject
statement.
to correction, Annexure A, my lord, is a representation, not the complaint, my lord.
Or to the additional chief secretary. Yes. Hence, ensure a free and fair investigation, request you to transfer, it is a representation.
That's right.
It is dated 19th
It is.
6, my lord.
Soon
it is.
after,
And his writ
soon
petition is
after
filed on
bank came to-
21/6,
All right.
2 days.
after the bank came to know about what has happened.
The FIR is in page 115, my lord.
I'll come to them.
Their complaint is against the 3 officials of the bank.
That's-
Come to the affair was lodged by somebody else. We did not lodge an affair. Now let us go on this footing that the banks makes a request to the government on a certain understanding that is a matter for CBI. So suppose there is no Master Circular. Suppose there is no 35A at all. How would I look at this letter written by the bank to the government of Karnataka? How would I look at it? So in the light of Section 35A and the Master Circular and my submission, that since the field is already assigned to and occupied by CBI under a certain framework of law, this request does not make any difference whatsoever. This letter cannot be read to mean that regardless of 35A and the Master Circular, you are now getting into the shoes of the central government under Section 5 and asking the state government to give its consent or a transfer. I think there is certain misconception about this letter, and therefore I say this letter does not really the final word on the law on the subject. So if kindly now turn over to the Master Circular for a minute.
Yes, sir.
Before that, can I request the Lordship to kindly turn to page 135? Correct, 135.
135, sir.
Yeah, it's a letter written by the bank to CBI. So this is virtually a lodging of a complaint with CBI. So the entirety of the events relating to this matter have been set out. And at page 144, I don't need to trouble you lots with the details of all that.
Yes.
Page 144, at the bottom of the tabular statement, based on the above facts and circumstances, we are of the firm opinion that the above allegations are acts of crime. Hereby affirm that no other complaint has been filed by the bank with any other law enforcement agency. Also intimate that no orders of the court or operation which limit the bank from lodging the complaint and initiating the criminal investigation. Therefore, request to conduct detailed investigation, etc. Then the competent authority, the Union Bank of India, issued prior approval under Section 17A, and the same are enclosed with this complaint. This complaint is being filed with the request take it on file, register FIR, investigate, apprehend and book the culprits involved, take action in accordance with the provisions of law against so-and-so, causing wrongful loss to the bank and wrongful gain to themselves, and thereby committing the various offenses, namely on all that.
Now CBI is investigating into this, into this
The
complaint?
CBI has taken it on record.
All right.
Now kindly,
3624.
all right. Now kindly now come to page 153, and we have the master circular, which begins at page 1. Let me just quickly take your losses to page 154,
Yes,
the
sir.
contents of the circulars.
Yes.
So we have chapter 3 called the Central Fraud Register, reporting of fraud to the Reserve Bank of India. Then chapter 4, reports to the board, quarterly review on frauds, annual review of frauds, and special committees of the board, and cases of attempted fraud, etc. Then chapter 5, closure of fraud cases. Therefore, this set of directions are a complete code in themselves.
Yes, sir.
Complete code in themselves. Now come to chapter 2, classification of frauds at page 157.
Yes.
These are, in my understanding, are illustrative. Then turning over to page 158, chapter 3, a central fraud 3.1, a central fraud registry based on the fraud monitoring returns filed by the banks and the select so-and-so, including update thereof, has been made available, which banks have been given access through user IDs and password, etc. The practice of issuing paper-based, all that is right. So we have a central fraud registry. Then 3.2, banks need to furnish fraud monitoring return in individual fraud cases, irrespective of the amount involved, by using and all that. Now, also, page 159, 3.2.3, fraud reports should also be submitted in cases where central investigating agencies have initiated criminal proceeding so moto and where the Reserve Bank has directed that cases be reported as frauds. Banks may also report frauds perpetrated in their subsidiaries, affidavits, joint ventures, etc. So therefore we have, and page, same page, 3.2.7, for the banks are also required to furnish developments in the fraud cases through update applications applied. Then kindly turn over to 161, reports to the board, that is the RBI. Banks should ensure that all frauds are reported to their boards promptly on their detection. Such reports should, among other things, take note of the failure on the part of the concerned branch officials and controlling authorities and give details of actions initiated against the official responsible for the fraud. Then there's a quarterly review, then the annual review of frauds. Then turning over to page 163, the importance of looking at banking frauds is, I think, is set out here in good measure. So we have 4.4 special committee of the board. Well, audit committee shall monitor all the cases of frauds in general. Banks are required to constitute a special committee of the board for monitoring and follow-up cases of frauds involving amounts 10 million exclusively. The special committee is to be constituted 5 members. So that's another detail of how the special committee will work. Then closure of fraud cases, kindly turn over to chapter 6 and particularly at page 167. In dealing with cases of fraud, embezzlement, banks should not merely be actuated by the necessity of recovering expeditiously amount involved. I stop here for a minute because one of the statements made in the charge sheet or otherwise is, oh, we have recovered about good part of the money. So, but should also be motivated by public interest and the need for ensuring that a guilty person do not go unpunished. Therefore, as a general rule, the following cases should invariably be referred to the state police or to the CBI as detailed below. So in private sector, foreign banks, category of banks, then you column 2, amount involved in the fraud, 10,000 above, 1 million above, all that is state police, if committed by staff, here the remarks, and 1 million above, state police, if committed by outsiders, on their own, and with the connivance of bank staff, staff officer. And 10 million and above, in addition to state police, serious fraud investigating office, Ministry of Corporate Affairs, Government of India, second to so-and-so, then remarks, details of the fraud ought to be reported to the SFIO in FIR format. Then public sector banks, below 30 million, 10,000 and above, but below so-and-so, state police, then we have remark coming by itself. Then we are looking at the third part of it, 30 million and above, and up to 250 million CBI, to be lodged with the anti-corruption view of the CBI in so-and-so and made so-and-so. Economic offences wing, more than 250 million with the banking security and fraud cell of CBI, and more than the 500 million to be lodged with the joint director CBI headquarters. Having regard to the quantum, the hierarchy within the CBI will also is also changed. Therefore, this is a principle as a part of the master directions issued by the bank, by the RBI, is binding on the bank. If it's binding on the bank, it says, I have no other option but to go to CBI. I don't go and request anybody else say, I need your consent. So inbuilt in this very scheme of, as I said, 35A and this master circular, that this scheme is completely outside the domain of the Delhi Special Police Establishment Act. For a very, very important reason. The important reason is, as I said right to begin at the beginning, the banking industry, the importance of ensuring the integrity of banking industry. And if the parliament thought 35A should be probably narrowly tailored, why can't state investigation agencies look into banking industry frauds? Well, the parliament could have done something differently.
No, state government does not.
Pardon?
State government does not look into the banking frauds of the ones.
That's why the master circular says that within a certain limit, state police will do it. But the moment the limit goes up,
limit goes up, it has to go to the CBI.
we have gone beyond that limit.
No, we've gone beyond that limit, definitely.
Yes, right.
Now, a crime is registered in crime number 118 of 2024 against banking officials.
Yes.
I believe those are all dropped while filing the charge sheet.
Yes.
So no banking official is there as on today as an accused in any crime. And in the crime that you have registered before the CBI, that is against those banking officials, the CBI is going on with that.
No, I look at it slightly differently. I'm a little concerned. I am not here as a...
sorry, but I just wanted clarification.
I'm sorry.
No, sorry, sir, but I wanted clarification, so I have taken it.
Yes. I just come back to it. I understand the nature of the dimension of the issues.
Yes.
And I also stand here not taking any partisan stand. I try to understand why RBI says that I will be the master of any banking fraud. But then if it's a very small amount, I don't need to worry about it. If that is so, then there is no other process or a procedure which can be conceived where somebody else, including a state government, will come and say, I have done an investigation regardless of the quantum of the fraud involved. Now, we began an investigation on an FIR given by somebody who turns out to be an accused himself later, and the banking officials, we exonerated them now. The FIR lodged by the chairman of the corporation was with very strong understanding of the fraud involved by the conspiracy or the banking official. Now, I will find a way out. The investigating agency can look at it saying, I will find a way out. CBI need not come in. I will exonerate all the bank officers now. Let them out at this point of time. Why should the state government then think, oh, office of the bank are out, CBI will also therefore be shown the exit doors. So you are, in a manner of speaking, done your investigation having regard to the implications which have emerged in the public domain. You thought this is the best way of going about shutting out CBI entering into the picture. Am I arguing and canvassing a case where if CBI comes, they will probably bring in the banking officials also in the net? May or may not be, I do not know. I am not speaking here on behalf of the bank as concerned about the officers also. If suppose the executive director and managing director involved, so be it. So, but that can happen only if an agency which is exclusively given the authority to investigate does the investigation. I mean, that means not only that. I don't want to travel into certain domains which will look very controversial and may also look maybe a little difficult to travel. I'm traveling this very, very cautiously. I mean, very. So anything the attorney says will be part of a public debate. So I'm very careful about that.
Yes.
But I try to look at it objectively as possible. One understands that in many of these transactions today in public affairs, public life, it's very difficult to draw a line somewhere and say, objectively speaking, this is true. And even if, and as one of the American historians said, objectivity is not necessarily neutrality. So therefore, the truth in public life today, many things happen. Many people, accountability, transparency, wrongs, errors. So they get mingled in the hailstorm of politics and then, but given that all that position and picture, I only thought that if RBI way back in 2016, when perhaps the current set of affairs where all this get mingled, probably were not there. Banking fraud going back to the old Mundra case, all the days onwards. The banking frauds were, of course, even then involved public, people in public life. Krishnamacharyas, all those, you'll have to remember that. But that was a slightly different issue altogether. Today, it is assuming all kinds of, like the octopus spreading its tentacles, if I am not wrong in using that. So the tentacles reach where we do not know. So if that is so, it's important that this law, that the Banking Regulation Act and the RBI authority go untrammeled. And therefore, I ask myself a question. If that is so, and if state government will come in only under Section 5 of the DSP Act, a very responsible state government will say, I have nothing to do with this matter. If CBI is the person to go under this law, and let it be. But if the state government says, no, I have something to do with this matter. I want to oppose CBI because I have power under Section 6. I have a sense of discomfort about that. The sense of discomfort is not, again, in any political sense, in the legal sense. In the legal sense, there is a sense of discomfort. Therefore, my submission is CBI will necessarily investigate this matter. It may reach the same conclusion as the conclusion with the state police have arrived at. It may reach yet another different set of conclusion where who will be involved and not, nobody knows about it. Perhaps CBI may even drop the investigation. We do not know. So to thwart or to at the threshold to say, Mr. CBI, you are an alien to this issue, I think is something to be questioned. I think something to be taken very, very carefully with a pinch of salt. So I don't think this judgment of just Supreme Court in the context of a maintainability of a suit and in the framework of Delhi Special Police judgment will have any relevance.
So that is one thing, sir. The other thing is the learned senior counsel was saying, you cannot choose the investigator. Now you fall back upon 35A even for that.
That principle is a broader principle in criminal jurisprudence.
No,
right? I cannot. In the
yes.
broader criminal jurisprudence, because long ago in Jobs, Hobbes, Leviathan said, look here, I'm taking over authority. The state will take over authority to do what it wants to in matters of doing justice. So I cannot do a private wrong. If I cannot do a private wrong by choosing an investigator who will probably shield and cover my wrongs. So that is the principle where that it comes in. But I am not, the bank is not choosing. If the bank says, I don't want CBA, I don't want state, I will want somebody else, I can understand that. It is not in administration of criminal justice, this principle is equivalent to a forum shopping principle. But the bank is bound by what the RBI says. Therefore, unless the master circular, somebody comes to the court and says that, look here, this master circular 35A are all good myths. The myths to be busted, right? Somebody will have to come to the court and say, well, I am challenging this. And who is RBI to say in such matters, and with an extended meaning which the attorney would like to give for 35A, who is the RBI to come and say all this? So somebody will have to come and challenge 35A, the master circular, and say, the bank cannot choose its own investigating agency. But I cannot read 35A or the master circular in that way. It is not the bank choosing it. The bank must abide by the discipline of ensuring that the banking integrity of the country, proceeds on certain lines. We have seen a large number of bank frauds across the world. The Lehman Brothers, all of us know about that. Yeah. So therefore, if today we are marching into an area, a digital area, a technology area, a new way of committing crimes, where anything can happen and all things can be put under the carpet, for good or bad reasons. So therefore, the master circular is not under challenge. 35A or the authority of RBI is not under challenge. And I am not choosing my investigating agent. I am bound to go by that principle. These are two answers to that question. Yeah. So having said that, I was looking at their reply, not permitted to go to their objections. Yes.
Yes, sir.
I would like to draw attention to one more legislation, which is a later day realization by the parliament of the importance of why CBI will be the investigating agency. This is the Banning of Unregulated Deposit Schemes Act 2019. That's right. So we had seen all kinds of deposit frauds from Sharda and onwards, and small time Pondicherry. We have seen all over the country. So this section 30 of this act says, on receipt of information under section 29 or otherwise, if the competent authority has reason to believe that the offenses relate to a deposit scheme or deposit schemes in which so-and-so takes property is involved and all that kind of thing, the competent authority shall refer the matter to the central government for investigation by the Central Bureau of Investigation.
Section 30 of the Buds Act.
That's right.
All right.
So if there is a mid-path card out here, it will refer to central government will then act and directly ask CBI to investigate. Another interesting provision here, as a follow-up, as a sequitur to section 30, like subsection 2, the reference made by the competent authority under subsection 1 shall be deemed to be with the consent of the state government under section 6. So even where the section 6 DSP Act may have some relevance, this legislation says your consent is not to be given expressly, it shall be deemed to be available to the competent authority. So today we have marched forward on understanding how special classes of offenses on public, having regard to public interest, will now be entrusted to CBI.
Yes, sir.
I looked into the details for the accused in the charge sheet. A very interesting narration about who are they. I'll just take a lordship through that, just broadly stating. Some of them are part of the officers of the Valmiki Corporation, and some are outsiders. And money has flown from money which belongs to the corporation has come into the Union Bank and flown out of the Union Bank and into so many hands. So it was very curious to understand how the money belonging to the corporation. And the bank has been used as a tool for getting into it and then making it flow out of it. And who are those people who are part of the conspiracy? Why are they involved? Why would a head of a corporation like this would be party to allowing its own money to get into somebody else's hands outside? Not certainly with good intentions for doing public interest work for the tribal advisory corporation. None of them have any connection with the tribe's development. So who are they? Why are they here at all? the answer will be given only by a proper investigation agency. All that the charge sheet says is money has been so-and-so, 50 lakh been given to so-and-so received 1 crore, etc. But why that money went into their hand? What is the reason behind that? For what purpose? I don't think the corporation, Valmiki Corporation, would like to share its bounty with some strangers outside for holy reasons. Therefore, it's a very important question. The charge sheet, therefore, would like to close it very quietly at this stage so that any further scan may not bring out certain unseemly things which might have happened in this case. And
the statement of objection,
Yeah.
you filed the charge. Please hold it.
what is the charge sheet?
Yeah, part of the sheet along with the state. They have filed it along with the state.
Very well. I think charge sheet is
Yeah, court records.
Of course, if we are not today converting the court into a regulator of the investigating agency or a trial court in some disguised way, so that certain things are debated in the court and then dealt with, answered indirectly or directly. I don't want to get into the question, but I was only looking at very curiously at how the charge sheet handled this. As for a doubt arises as to why the charge sheet would like to close it the way it would like to close it.
Yes.
That's broadly my response to the preliminary submissions. And yeah.
We'll hear the other side
Yes, sir.
and we'll answer the preliminary submissions and then get into.
Very well.
ಇವತ್ತೇ ಮಾಡ್ತೀರಾ?
Please, Madam,
If continuing?
if it is only on the preliminary point, my
Only
lord,
on the preliminary issues.
yes,
I'll first decide about the preliminary issue.
please,
Because you've given me a judgment saying that
Yes,
it
yes.
should not,
my lord,
it's
if
not
it is not
maintainable here.
inconvenient to my friend, have it tomorrow or
That's all right.
Tomorrow we discuss.
No, it's, I am here. You can choose your date. I have no problem at all.
I don't want,
Since I've heard this, I'll post it for further hearing, whichever date you want.
or any day convenient to learn it.
I understand that. I also want to see that the court's availability is also equally
No
important.
problem. Friday, Monday, anything.
Please.
Because I think we are here up to the first, from the second it is closed. For vacations. Second, Allah? First one.
Any date.
Friday ಬೇರೆ ಇದೆ. ಯಾವ ದಿನ ಇದೆ?
I'm sorry, this calendar is always.
No problem. You take your time. Even if the learned ASG would inform the court, that would be fine. No issues.
It's convenient for the court. I think we can have it on 30th and conclude.
All right. Monday, yes.
Please, ma'am,
No
please,
problem.
please.
I'll do one thing. On Monday, you answer on preliminary submission.
Please.
As also on the merit, we will decide it.
Please,
Yes.
please, ma'am.
That's good.
So that piecemeal won't be there, we'll close it on that day.
Fair enough.
Yes.
Yes, ma'am.
Heard the learned Attorney General, along with so and so, appearing for the petitioner, the learned Senior Counsel, B.V. Acharya. Now the special, how do I address?
Special public prosecutor is what the nomination.
Special Public Prosecutor for the state government, learned Senior Counsel, Professor Ravi Kumar, representing the sixth respondent and all others. List the matter on 30th. What time? We'll take it at 2:30?
Even at the early part of the time.
Yes. Take
Whatever time would suit your lordship.
2:30 is fine?
Even I can come in the I can come in the morning hours. No problem.
No
We'll have
problem.
it in the morning will be.
All right. We'll
There
take
is
it
a
as,
spillover. There is a
all
spillover
right, yes.
to the afternoon.
Amendment. Take it. Yes, 30th. 30th for the hearing.
Grateful.
Obliged.
ಅಲ್ಲಿ bracket ಅಲ್ಲಿ bracket.
Filing my objection.
Yes, sir. Give it. Give. ಅದೆಲ್ಲ pleading judgments ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ. I'll just go through them.
Yes.
Everything, yes. continue the list. Omkar. 12.
This one.
Huh?
Serial number 11.
ಸ್ಟೇ ಆಯ್ತು ಸರ್, ನೀವು ಇರ್ಬೇಕಾಗಿಲ್ಲ ಇದು. ಸ್ಟೇ ಕೊಡೋ ಕೇಸ್ ಇದ್ರೆ ನೀವು ಇಲ್ಲದೆ ಇರೋ ಕೊಡ್ತೀನಿ. ಎಸ್ ಸರ್. 12 CC 2017 Omkar.
It is a false allegation where the complaint has been filed
False allegation ಇರ್ಲಿ.
after a week of 7
ಇವತ್ತು
days, the
ಏನ್
complaint has
ಸ್ಟೇಜ್,
been filed,
ಯಾವ
my lord.
ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ? What is the stage today?
It is in the evidence stage, my lord. It's a 2017 matter, evidence stage.
No, evidence stage ಅಂದ್ರೆ ಅದಲ್ಲ. If charges are framed and trial has commenced, I will not interfere, sir.
It is still in the stage of evidence. Only the documents
In
have
the
been
stage of
filed.
evidence ಅಂದ್ರೆ trial has commenced.
7 years delay ಇದೆ already. Complaint file ಆಗಿದೆ. There is 7 days delay in filing of the complaint.
7 days.
Please,
Not fatal.
15/11 is the incident.
Damage to public property is there, sir. ನೋಡಿಲ್ವಾ file?
We are not the party. Copies are not.
Why you are the party, sir?
Copies have not served to us.
Damage to public property ಅಂದ್ರೆ ಸ್ಟೇಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
Copies have not served to us.
ಗ್ರಾಮ ಪಂಚಾಯತ್ is the complainant.
Copy is not served. Copy is
First respondent ನೀವೇ. Copy serve ಮಾಡಿ.
Please.
Counsel for the petitioner to serve set of papers upon the counsel for the respondent list on 15th October in fresh matters list. Yes. Arrears ಎಷ್ಟಿದೆ ವಿನಾಯಕ್? Where is Vinayak?
He is appearing on other matter, my lord.
Ask him to come. I'll dismiss it otherwise. Yes. Asur.
14.
I'm for petition. Releasing GPN.
The petitioners are A8, ilva ಏನು file? A8 and A9. The look, a perusal at the complaint would not indicate any overt act or direct offense against these petitioners. Therefore, there shall be an interim order of stay for a period of 8 weeks. Yes.
Stays.
ಈಗೇನು ಹೇಳಿದ್ದು ಸರ್? Next.
15.
In the meantime, 15 ಅಲ್ಲ. 15
Charge sheet will be filed
will be filed.
today.
Consensual.
In a similar matter.
Covered by Dhruvaram.
Friend can take the charge sheet, challenge the entire charge sheet. I've been told yesterday. Charge sheet
In
will
similar matter, this honorable court,
ಏನ್ ಸಿಮಿಲರ್ ಇದ್ರಲ್ಲಿ 376 ಅಲ್ಲಿ ಏನ್ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ಇಲ್ಲ.
in similar,
What similar, sir?
similar circumstances, my lord.
ಏನು ಎಲ್ಲ ಸಿಮಿಲರ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸ್ 376 ಅಲ್ಲಿ?
No, my lord,
No.
it's a false promise of the,
Why did you promise?
no, it's not a promise. He has not given any promise, but
Okay.
the allegation is,
Without promise, what did you do then? Nothing.
it's a
Yes.
false, by the false, like interim.
ಚಾರ್ಜ್ ಶೀಟ್ ಮಾತ್ರ ಇಟ್ಕೊಂಡಿಲ್ಲ ಸದ್ಯಕ್ಕೆ.
if it is already filed, I'm not.
ಆಲ್ರೆಡಿ ಫೈಲ್ಡ್ ಗೊತ್ತಿಲ್ಲ ಏನಿವೆ. ನಂಬರ್ ಇದೆಯಾ?
ಇಲ್ಲ, yesterday they said they
Not
will
yet
file.
filed, my lord.
Already, huh?
Not yet filed.
The learned, the petitioner is before this court, so and so. A perusal at the complaint would indicate that the relationship between the petitioner and the complainant was consensual for over 2 years. Later, it transpires that when the relationship turns sour, an offense of rape under section 376 has sprung. The permitting further proceedings / investigation against the petitioner would run foul of the judgment of the apex court in the case of Dhruvaram so and so 2018-19 SEC page 181. Therefore, there shall be an interim order of stay of further proceedings by the petitioner to the next date of hearing. 16. In the meantime,
For the petitioner, my lord.
17, same order 17, sir. Idhar sir, ನಿಮ್ ಸ್ಟೇ ಆಯ್ತು ಹೋಗಿ. Yes.
Same order.
ಕೊಡಿ ಅದು ಟ್ಯಾಗ್ along with so and so. Next. Vinay Kuttappa. In the meantime, 19 also in the meantime for a period of 8 weeks.
19.
Yes, sir.
So you appear for the petition.
B report accepted and closed. Notice ಹೋಗ್ಬೇಕು.
My lord, no,
one
my
petition
my lord, I'm for the petitioner in this matter, my lord. My lord, I'm for the petitioner in this matter.
Madam, you are the complainant,
My
right?
lord, I'm the complainant, my lord. No notice has been served on the complainant, even from the
B
court.
report
my lord.
is accepted and case is closed.
Okay, with a one-line order that notice served,
Any
none
one-line order.
none appears.
Madam, once
Please.
B report is accepted and closed, we have to hear the accused. Yes.
My lord, I am relying on your lordship's order, my lord. My lord, I'm relying on your lordship's order. In a similar
that
matter,
is-
your lordships have.
The case close ಆಗಿದ್ರೆ definitely it is necessary. ಓಡಿ ಅದು ಯಾವ್ದು ನೋಡಿ.
ತಮ್ಮ ಆರ್ಡರ್ ಸ್ವಾಮಿ.
ರವಿಕುಮಾರ್ ಕಾಂಟ್ರಿ ಇದೆ ಅಂತನಾ? Were you not heard while accepting the B report and closing it? How many occasions ಕಾಯ್ಬೇಕು ನಿಮ್ಗೆ? See the order sheet. ನೀವು ಬರೋವರೆಗೂ ಎಕ್ಸಾಮ್ ನಡಿಬಾರ್ದು. When you appear, the exam should be taken. ನೀವಲ್ವಾ?
And the notice was not served, madam.
What notice was not served? Look at the order sheet.
Page number 41 may be looked at, my lords. Adralli,
Page 42, it says notice of ಖುದ್ದು ಜಾರಿ ಮಾಡಲ್ಲ.
Lack of ಎಲ್ಲಿದೆ?
42.
ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ದಾರಿಗೆ ಖುದ್ದು ಜಾರಿ ಮಾಡಿರುತ್ತಾರೆ. ಯಾವತ್ತಿದು? ಒಂದ್ಸರಿಗೆ ಬಿ ರಿಪೋರ್ಟ್ ಕ್ಲೋಸ್ ಮಾಡಕ್ಕಾಗತ್ತಾ? ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿ. Yes, we'll post it tomorrow in the fresh matters list. We'll dispose it tomorrow. Next,
21.
Petition.
the petitioner is before this
Attesting
court, so and so. Huh?
Petitioners are attesting.
What is that? The petitioners are accused 4 and 5 are said to be the attesting witnesses of the instrument that has now become the bone of contention. It is a settled principle of law that the attesting witness cannot be drawn into the web of crime, as they would not be aware of drawn web of crime. The issue stands covered by plethora of judgments rendered by the apex court. Therefore, there shall be an interim order of stay. Next.
22.
Really an afterthought.
What afterthought?
Let me just see.
376, sir.
My lords, we're trying to see page 66.
I've seen.
It's clearly, my lords, she says that please
What?
be happy with your life. Please go ahead and marry her.
Be happy.
Clearly an
You're
afterthought.
not happy now?
No, it's clearly an afterthought. My lord, she says that.
376 register ಮಾಡಿದ್ರೆ happiness ಎಲ್ಲಿರುತ್ತೆ?
Lords, may kindly just see 60.
Yes, sir. In the meantime, for a period of 8 weeks. Yes.
Great.
Next.
Great.
23.
Who is in possession?
I'm in possession, my lord.
What are the numbers of the suits?
My lords,
OS number?
OS 391 of 2018
OS 391?
and 204 of 2022.
ಬರ್ಕೊಂಡ್ರಾ? ಇಲ್ವಾ?
My lords, OS 183 of 2018 and 204 of 2022. There is
The
a registration.
petitioners are said to be in possession of the property. The complainant and the petitioners are in dispute in OS so and so. ಬರ್ಕೊಂಡಕ್ಕಾಗಲ್ಲ? In so and so. The prima facie, an offense under section 447 can be laid against a person who is not the owner of the property, but the petitioners claim to be in possession of the property, and therefore a criminal trespass cannot emerge into their own property. Therefore, there shall be an interim order of stay, so and so, to the next date of hearing. Next.
Please.
A5 and A6 Kashkan. Next. 4 and 5, sorry. A4 and A5 Kashkan. Next. Stayed.
5.
Yes. Husband.
No, it says 353, my lord. Section 353.
ಯಾವ್ದು, 20?
25, my lord.
ಇಲ್ಲ, mistake ಆಗ್ಬಿಟ್ಟಿದೆ.
Petitioner is on accused number 3, my lord.
Oh, this one. Yes, sir.
Petitioner is on accused number 3.
Learned additional SPP is directed to accept notice with respondent.
Kindly see this.
No, sir.
No, my lord. Kindly see this, sir. Page number 72, my lord. They are saying, Lord, they are arrested on 23 on night itself. But I'm kindly see. They are.
Let him see. Yes. List on 16th October in the fresh matters list. Next.
26.
Connected matters, the interim order is there, my lord.
Connected matter.
There are 3 complaints filed against me, my lord. In 2 other matters, this honorable court was.
Tag this petition. Tag this petition. Same order. Next.
Interim order, my lord.
Not a case. ಅದರಲ್ಲಿದೆಯಾ?
ಇದ್ರಲ್ಲಿದೆ, ಇವೆರಡರಲ್ಲೂ ಇದೆ.
ಇದರಲ್ಲಿ ಇಲ್ಲ ಬಿಡಿ. Yes, next.
My lord, what has happened is a family transaction.
Granted, sir. Yes.
27.
Ashkan. Next.
Except A1.
Huh?
A1 ಇದೆ.
A1 ಇಲ್ಲ. Husband. Husband ಇಲ್ಲ. Other. Yes, next.
28.
In the meantime, now you can go for lunch, sir. Yes, next. Stayed, sir. Stayed. Yes, sir. Yes. 20. ಯಾರಿದು? ರಾಮಚಂದ್ರ ಅಯ್ಯರ್.
PCRF. 150.
29, my lords, bring the petition admits.
ಎಲ್ಲ.
See note 29.
RERA has extended the time.
No, what has happened here is that one, my lords, he has purchased the property in 2008.